Morning, everybody. We'll start in about 1 minute. Good morning, everybody. For those who don't know who I am, I'm Marvin Genzer. I'm your Executive Director. And welcome to what is actually the first of our regular CLE sessions for the year. This one is still a webinar, but we expect that after this one, all remaining events for the year, hopefully, are all going to be live. They're currently scheduled that way, and we're hoping to maintain that program throughout the rest of the year. So we're looking forward to actually returning to a normal lunch and learn for these regular sessions. Just a few comments about upcoming events. On the 27th of April, we have our spring reception. All in-house lawyers are welcome. Whether you are a member or not a member, you are welcome, and we invite our sponsors will be invited. It's our opportunity to thank them for supporting the chapter. And that's going to be at the North Carolina Museum of Art on Wednesday, April 27th. It goes from 6 to 8. It's always a beautiful event and an opportunity for us to network with each other and thank our sponsors. On May 4th, we're going to have our first live CLE. It's the Future of Money, put on by Fox Rothschild. That's going to be at the Umstead. Hopefully that'll be an attraction for everybody to start coming to live events. On May 25th, we have an event on drafting commercial contracts put on by Morningstar. That's going to be at the Park Alumni Center at North Carolina State. Also live, of course, and same thing. It'll be our typical lunch and learn. These lunch and learns call for 11:30 to 12 as to get opportunity to get lunch and to network with each other, and 12 to 1:30 being the CLE event. On May 25th, we have our intern-extern event. That's where members are invited to invite their interns, externs, their summer intern, externs to come to this event, how to get the most out of your summer experience. And it'll be a panel discussion from 5 to 6:30 at the Prestonwood Country Club, followed by a reception also at Prestonwood. All members are welcome to attend the panel discussion if you wish, but certainly the reception following the panel discussion at 6:30 to 8. And that'll be also on May 25th. That's that same afternoon that we're going to have that session at the Park Alumni Center. On June 15th, we're going to have a session by Ogletree on employment law. The venue has not been chosen yet that I'm aware of, but that'll be the next event. And after that, you can expect regular monthly events. I've got them all listed on our website on ACC. Don't try to register for those. Those are not necessarily final dates or times, but I put them there so you can plan your calendar in advance. But when you get the invitation is when you can register, and you'll get a registration link just like you got for this one for all our events. I'm using the registration links now for using sponsor platforms. With that, anybody have any questions, by all means, reach out to me if you have any issues or questions about our upcoming events. With that, we want to thank Nelson Mullins for putting on today's event on litigation management. And with that, I'm going to pass you over to Bob Wilson, who will introduce the rest of the panel and introduce the firm to you. Thank you all for attending today.
Thank you, Marvin. Good afternoon, everyone. I'm Bob Wilson, the office managing partner for the Raleigh office of Nelson Mullins, Riley, and Scarborough. I'm also a healthcare corporate lawyer. Nelson Mullins is a national law firm with over 900 lawyers and 30 offices across the United States. I'm part of this community in the Research Triangle area for about 20 years. We also have offices in Winston-Salem and Charlotte. Nelson Mullins is delighted to host this webinar today on litigation management tips for navigating dispute resolution efficiently and cost effectively. My firm colleagues, Chris Blake, Corey Patterson, and Candace Friel, are here to present 3 discrete topics for your consideration. Chris is to handle the forum considerations, Corey will handle privilege protections, and Candace will handle discovery matters. Just a brief word about the presenters. Chris Blake has over 30 years of experience in handling a variety of complex commercial disputes in state and federal courts, as well as in arbitrations and other dispute resolution forums. Chris co-leads the firm's insurance group. Corey focuses practice on complex civil litigation as well. Corey also is involved in white-collar litigation and government internal investigations, as well as insurance coverage issues and toxic tort litigation. Candace is a commercial litigator in our Winston-Salem office with a concentration in the healthcare space, and represented, among others, hospitals and providers throughout the state in federal, state, business, and administrative courts, as well as in alternative dispute resolution forums in a wide range of areas, including employment disputes, payer disputes, as well as business torts and antitrust matters. We're going to be happy to address your questions today through the chat feature of program here. And so now, Chris, I'd like to turn it over to you to begin with forum considerations.
All right, thank you, Bob. And if we could advance a couple of slides forward. And there we go. So good afternoon, everybody, and thank you for joining us today for the presentation. I'm going to address forum considerations, and the first topic I'm going to talk about is forum selection. Because at the outset of any type of dispute or litigation, making sure that the dispute is chosen for the correct forum could have a huge impact on the outcome of the case. The first issue I want to address is jurisdiction in federal district court. Federal jurisdiction is established in one of 2 ways: diversity of citizenship or federal question jurisdiction. Diversity of citizenship requires that the parties to the lawsuit be diverse, which means that they have to be citizens of different states, and also requires that the amount in controversy be in excess of $75,000. For a corporation, its citizenship is determined by the state where it's incorporated and the state where it maintains its principal place of business. One area where people sometimes get tripped up on is if one of the parties is a limited liability corporation, the citizenship is determined not just by where the principal place of business or state of incorporation is, but where the principal place of business and state of incorporation of each of the members of the LLC are located. So if you have a case involving an LLC and you're interested in evaluating whether or not you can satisfy diversity jurisdiction to be in federal court, you have to evaluate the citizenship of each of the members of the LLC. Federal question jurisdiction is where a dispute arises under a federal statute, such as federal copyright law, federal trademark law, antitrust law. And there, if you can satisfy federal question jurisdiction, the citizenship of the parties doesn't matter because you can establish jurisdiction through federal question. If a suit is filed against a business in state court, it's a good idea to always evaluate whether the case can be removed to federal court, and you have to do it quickly. The deadline for deciding to remove a case from state court to federal court is 30 days from the time you either are served with a complaint or the time you receive a copy of the complaint. So if you are considering trying to remove a case, make sure you and your counsel discuss that issue very early on to make sure that that deadline isn't missed. So what are the benefits of being in federal district court? Because most of our business clients prefer to be in federal court than in state court. One of the great benefits of being in federal district court is that the case is assigned to a single district court judge who oversees all of the proceedings in the case, including pretrial motions, discovery motions, dispositive motions, and trials. And federal district courts are generally, in my experience, more familiar with complex business type issues and business disputes. Federal district courts have judicial clerks, which is unlike most state court judges, and they generally have more time to devote to matters that are pending before them. In federal court, you can also generally avoid a local bias from being in state court in a remote county. Oftentimes, business clients are concerned about being in a state court outside of the metropolitan areas in North Carolina because they feel like their opponents might have a more of a home cooking in front of a local judge. And being in federal court helps you to avoid that bias. And finally, if the case, in the unlikely event that a case gets to trial, in federal court, jury pools come from a broader geographic scope. In North Carolina, we have 3 federal districts, the Eastern, Middle, and Western District. And rather than just having your jury pool be from the county where the case is assigned, if you're in state court, the jury pool comes from a broader geographic area across the federal district. If we can go on to the next slide. So I now want to talk about state superior court. So if your case isn't in federal court, you're likely to be in state superior court, where most commercial litigation is filed in state superior court, where the amount of controversy has to exceed $10,000. In North Carolina, there's a superior court for each county, and venue in that court is established by where either the plaintiff to the case or the defendants reside, or where the subject matter of the dispute arose. So if you find yourself a party to a lawsuit, you can evaluate whether the venue is proper, and if it's not proper, you can file a motion to transfer the venue to the proper superior court in another county in the state. There are certain drawbacks that I have found to superior court jurisdiction that many business clients are not fond of. In North Carolina, we have a system where superior court judges rotate every 6 months, and they may not, so a case may be filed in a certain county. Say if it's filed in Wake County, you'll get a different set of judges for the first 6 months of the year and another set for the second 6 months of the year. So no single judge is assigned to the case. And because of that, you could have one judge who decides pretrial motions to dismiss, another judge who decides discovery motions, and another judge who decides a dispositive motion. And because the judge who is assigned to a case for trial may not be the one who decides a dispositive motion, we have had situations where we don't feel like the judge gives the dispositive motion the attention it deserves because they're not going to be the ones who try the case, unlike if you were in federal court. Another drawback is to avoid shopping for certain judges. What has happened in most state superior courts is that the county trial court administrators have gotten to a practice of not announcing which judges will be serving in a given week. So when you look at a calendar and you try to calendar a motion for a hearing, oftentimes you're not going to find out who your judge is until the very last minute, which makes it very difficult to try to find a preferred judge who might have certain expertise to handle a particular matter, and makes it a little bit more difficult to get cases calendared for a hearing. We can go to the next slide. So despite some of the drawbacks I was just talking about with regard to state court jurisdiction, there are some alternatives that are available if a case is going to be in state court. One is pursuant to Rule 2.1 of the North Carolina Rules of General Practice and Procedure for state courts. Under Rule 2.1, parties can agree to use a single superior court judge to be assigned for the entirety of a case. And that judge can be identified by the parties and doesn't necessarily have to be from the county where the case is pending. What this procedure requires is the agreement of the judge and a request by the senior resident judge in the county where the case is pending to the Chief Justice of the State Supreme Court, who then approves the request. And what I have seen done in cases is that I have a case now, it's a class action case, and I reached out to the lawyer for the class and said, look, this is a class action case, we're in state court, we should agree to use a Rule 2.1 judge. They were in agreement, and we made phone calls around to the counties around Raleigh to identify a judge. We found a judge we would agree to, he agreed to accept the appointment, and then we went through the procedure of getting him appointed to be our judge. Once you have that agreement from a judge to be a 2.1 judge, in my experience, the rest of the approval process is pretty routine. So this is one option to avoid some of the drawbacks in state court. If we can go on to the next slide. The other option that is available in state court is the North Carolina Business Court. The North Carolina Business Court has been around for 20 to 25 years, and it's a special branch of the Superior Court that is designed to handle complex corporate and commercial disputes, and it is generally modeled after the Delaware Chancery Court. Currently, there are 5 special Superior Court judges who have been assigned to the business court that sit across the state. There are 2 that are located in Charlotte. One is in Raleigh, one is in Greensboro, one is in Winston-Salem. In order to get a case into the business court, you have to meet the requirements of a particular statute, section 7A-45.4. That statute identifies the types of cases that the business court has jurisdiction over, and that includes disputes involving the law governing corporations. So if you have a dispute involving breaches of fiduciary duty, the duty of loyalty, corporate governance, all of those cases arising under the Business Corporation Act can be brought before, designated to the business court. Cases involving securities, antitrust, trademarks, and trade secrets also can be designated to the business court. And contract disputes, where the amount in controversy in the case exceeds $1 million, and at least one party is a corporation, and all parties to the lawsuit consent. Those are the typical ways you get cases designated to the business court. And being before the business court has basically, essentially all of the benefits of being in federal district court, because you will have a judge who is assigned to the case. He will oversee the case from start to finish. Business court judges, like federal district court judges, have law clerks. And when they decide motions, they generally write written opinions that form a body of law decided by the business court on a lot of these business law type issues and disputes that come before the business court. Another real benefit of being in the business court is that there is an appeal that comes up from a decision of the business court. The appeal is direct to the North Carolina Supreme Court. In North Carolina, we have an intermediate appellate court called the North Carolina Court of Appeals, but the legislature changed the law several years ago. So now any appeal from the business court is a direct appeal to the North Carolina Supreme Court. If we can go to the next slide, please. So now I'm going to talk a little bit about some alternative dispute resolution options. And these are options that would involve having your dispute decided outside of a court litigation proceeding. The first I want to talk about is early mediation of disputes. This has become a popular option. I've seen a lot of businesses include provisions in their contracts that require the parties to engage in an early mediation of a dispute before either side either files a lawsuit in court or commences an arbitration proceeding. I have found in my experience that this can be a good idea so long as both sides to the dispute are motivated to engage in these discussions and prepare to compromise their positions. If you have one side who's got a position where they're dug in and they don't want to budge off of it, it's difficult, even if they have to participate in an early mediation, to reach an acceptable resolution. One possible drawback to engaging in an early mediation is that you do this prior to engaging in any discovery. So there's a risk that you may be foregoing discovery of facts and evidence that could support your position or undermine your opponent's position and enhance your settlement position. So you just have to understand that in an early mediation, you have to forego full discovery on what your opponent's position and what the evidence might be. And the other thing I would suggest is if you do an early mediation, try to make sure that's not your only opportunity to mediate a dispute. Make sure an early mediation doesn't preclude the option of mediating the dispute later in the case. Because once parties engage in some discovery and have full knowledge of what their position is and what their opponent's position is, if you can't get it resolved early, there's still opportunities to resolve the case prior to having it decided in trial or in another forum. If we can go to the next slide, please. The next option for alternative dispute resolution is arbitration. And this is a method of resolving disputes that I have found is generally favored by business clients. Arbitration is by agreement when parties to a contract include a provision to arbitrate any dispute between them. Agreements to arbitrate are generally always enforced if they are challenged in court. So if one party to a contract that has an arbitration provision ignores that provision and goes ahead and files a lawsuit anyway, the other side always has the option of filing a motion to compel arbitration. And so long as there is any agreement to arbitrate that's in that contract, the courts will compel arbitration, stay any further litigation, and send the parties to arbitration, which is where they agreed to go. Arbitrations are typically administered by an organization such as the American Arbitration Association. There are some other organizations that oversee arbitration proceedings. Each of them have their own sets of rules and procedures. So if you find yourself in an arbitration, make sure that you and your counsel are familiar with the rules of those organizations that govern those disputes. Next slide, please. So what are the differences between arbitration and litigation? The first consideration is time. And I say here that arbitration can be a speedier way to resolve your dispute than proceeding in court. And I emphasize can be because it really depends. If the parties still want to engage in lengthy discovery, document productions, depositions, and other methods of discovery, an arbitration in a complex case involving a significant sum of money can still be a fairly lengthy proceeding that could take 12 months or more before you can get to a hearing. Cost. Arbitration can be a more cost-effective way of resolving a dispute. If the arbitration can be brought to a hearing in a reasonable amount of time, businesses can reduce the cost of litigation, the amount of fees they have to pay their attorneys to bring the case to an arbitration hearing. But one thing you have to be aware of is that, for example, through the AAA, if that's how your arbitration is proceeding, there are fees associated with bringing the arbitration. There are fees associated with the arbitrators that have to be paid. And so when you get to the end of the dispute, the actual cost of an arbitration may be the same, maybe a little less, a little more than actually proceeding in court. One of the benefits of arbitration is the expertise of the arbitrators. Parties to an arbitration have some say in who the arbitrators will be and can select arbitrators with relevant industry knowledge and expertise. If you have an intellectual property dispute, you can select an intellectual property lawyer to be one of your arbitrators. You can have construction industry experts where you get expertise on the panel that you may not have with a judge who is assigned to your case. One drawback of arbitration versus litigation is that in an arbitration, arbitrators are not bound to follow the law or the rules of evidence or procedure. So when you get to an arbitration hearing, you're not going to hear a lot of objections. And any evidence that anybody wants to bring in, the arbitrators will generally say, we're going to let the evidence in, and we have the knowledge and expertise to weigh that evidence and determine, what value it has to each side's position to the arbitration So, the rules of evidence that might apply to keep evidence out in court are probably not going to work in an arbitration proceeding. Equitable results. Arbitration always leaves the possibility that the arbitrators will try to find some equitable result to give both sides to the case a little bit of something. My experience with arbitrations, this happens almost probably 75 or 80% of the time, where they're not going to let one side win everything or lose everything. And they'll generally try to find a middle ground that leaves everybody to the arbitration saying, well, I didn't get everything I wanted, but at least I got something. And I think that arbitrators almost are trained to probably reach that kind of result when they get a case. The next is appeal rights, and you have to understand this is very, very important. Once an arbitration award is entered, the ability to challenge that award, to have it vacated in a court, is very limited and very specific. I put in here fraud or bias of the arbitrator. I mean, you literally have to show that the arbitrator was paid off by the other side to get an arbitration award vacated. And an arbitrator can reach an award that's completely wrong or have absolutely no legal basis whatsoever. And if it's challenged in court, a judge is going to confirm the arbitration award because there's a strong judicial preference in favor of arbitration. Arbitration allows these disputes to be decided in a different forum, and courts are more than happy to have those issues decided that way. And they don't want to get into fights between the parties challenging the arbitration award that they agreed to once it's completed. One other important factor that I left off of this slide is that arbitration disputes are generally confidential, whereas a dispute in court is a matter of public record. So if parties have a desire to keep the dispute resolution private, to exchange discovery, and conduct a hearing in private, arbitration gives you the option of doing that. Next slide, please. So I finally want to just share some of my personal observations of my years of experience in dealing with arbitration type proceedings. I think arbitration is a good alternative for a business to consider, so long as the amount in controversy doesn't exceed does not exceed a certain threshold. And I put in here, for an example, $1 million. You can put into your arbitration agreements what the threshold is, and what that does is gives you some certainty of what the level of risk is. If you know that the amount in controversy can't exceed this amount, then you know what the potential downside is going forward. For large commercial disputes involving significant amounts in controversy, I would typically advise a business client that you want to be in court, because in court, the dispute is decided under the law. It's subject to the rules of procedure and evidence. And if you get an adverse decision at the trial court level, if you're in court, you have the ability to appeal that decision to a higher court. If you find yourself in a commercial dispute that is subject to arbitration, and you don't have the option of being in court, I strongly recommend you consider a few things. Number one, have that dispute decided by a panel of 3 arbitrators and not a single arbitrator. If you have a single arbitrator, you run the risk of having that arbitrator, believe one witness over another, wake up on the wrong side of the bed and make a decision that you can't do anything to challenge. If you have a panel of 3 arbitrators, you at least have 3 people sitting in the room debating what the evidence they heard, what the testimony they heard, and how they should reach their decision. And I have found having 3 arbitrators is always a better option than having a single arbitrator. And if you have a panel of 3 arbitrators, most of these arbitration organizations have a lot of retired judges who serve as arbitrators. And I have a strong preference for having prior judicial experience on my arbitration panels, because even if they're not required to follow the law and the rules of evidence, if you have a retired judge on the panel, my experience is they bring their prior experiences on the bench with them into an arbitration. And I think that they have a very strong influence over other private arbitrators in deciding and reaching decisions on disputes. And the last point is that if you do have arbitration in your contracts with your customers, with your employees, with other counterparties, make sure you include a class arbitration waiver in your arbitration provision. Class arbitration is something that the AAA developed probably about 15 years ago. And if you don't have a class arbitration waiver, many arbitrators will construe a very general, broad arbitration agreement to allow for class arbitration of disputes. I handled a class arbitration case for some healthcare clients that were in a dispute with their network of providers. That was allowed to proceed as a class arbitration, and that case lasted 9 years before it was concluded, because it was just a complex case, but the AAA rules for class arbitration, it just allowed that case to take on a life of its own, and we were unable to get it to a hearing, unable to get it resolved. We had decisions that were appealed, that were sent back. It was just a nightmare for that client. So it could have been avoided if they had a class arbitration waiver. And so if you have arbitration provisions in your contracts, I can't advise you strongly enough to make sure it's got a class arbitration waiver to avoid that. And I guess I don't see any questions. I don't know if anybody else can see any questions, but that is all I have. And I thank you for your attendance today and your participation in this, and for allowing me to make the presentation. And with that, I'll turn it over to Corey Patterson.
Everyone, my name's Corey Patterson. I want to talk a little bit about privilege considerations and how those privilege considerations kind of factor into whether it's litigation or you're responding to a subpoena. But when you're in-house counsel, particularly the attorney-client privilege is pretty much a day-to-day event, and you really don't appreciate, I think, the how important it is until you get the subpoena or you get the litigation complaint that comes up. And so, by then it's often too late to protect some of your confidential or your crucial communications and information from disclosure or discovery. So I want to discuss today some good internal structures and some habits you can kind of implement and think about in terms so that you don't have to turn over documents, either it's to a regulator or to opposing counsel during discovery. Disclosure of confidential documents and information can normally be sought in a lot of different contexts. There's the regulatory context. There's the subject. You could be the subject of a subpoena from a recent transaction, target of a government inquiry or investigation, even in a sense where there's a criminal investigation of one of the employees, or the company itself. So it's not a question so much as to whether this will happen, but I'm sure that you all deal with this pretty much day to day. And so in those contexts, you want to be able to identify kind of what the privilege documents are, and whether you can, in good faith, withhold those documents from production and keep them remaining confidential. I won't spend a lot of time on this particular slide, but this is just the elements of the attorney-client privilege. There must be the existence of an attorney-client relationship, which normally is not an issue generally when you're in-house counsel. The communication being confidential. Not a whole lot of litigation on that particular front, just because generally the inner workings of a company are confidential. There are certain circumstances in which I was in-house counsel for a bank prior to coming to Nelson Mullins, and so we use third-party vendors as well as consultants for a lot of the projects that we worked upon. And so a lot of times that particular piece would come into play in terms of attorney-client privilege and those actually being confidential. The third is the communication relates to a matter which the attorney is being professionally consulted. I think that is probably the most litigated portion of the attorney-client privilege and for privilege considerations. We constantly see that, there, at least, for a lot of organizations or a lot of companies, folks like to loop in legal in hopes that, it won't show up or as for cover, essentially for some of the communications. I know it was kind of a running joke when I was in-house. Hey, let's just, we'll loop in Corey, and that way at least we can keep any of the communications that we're talking about confidential. And it doesn't quite work that way, although we wish it did, but it doesn't. Fourth element, the communication was made in the course of giving or seeking legal advice for a proper purpose, which I think is probably the most vital. What is the proper purpose? And were you actually providing legal advice at the time the communication came through? And so that's going to be the crux of the majority of the analysis in terms of whether, something's going to be privileged, at least for attorney-client privilege purposes, is, were you properly providing legal advice? And fifth, the client has not waived the privilege. The client ultimately holds the privilege in this particular privilege. So the not waiving, the company likely will not waive it. And we'll talk a little bit about a little bit of waiver implications. But before we do that, I do want to go ahead and test you guys while we are kind of at a good point here to see, what everyone on the call kind of thinks about some true or false hypotheticals. And so the first one is labeling a document or an email communication privilege and ensuring counsel is copied on it entitles it to protection by the attorney-client privilege. You all should be able to see that you can enter in a true or false to this particular statement, and we'll see where everyone lands on this. Give everybody a minute to kind of respond. All right, everybody got it entered in? Can you show me the results? Uh-oh, like we lost it.
84% said false, 16% said true.
All right, that is false. So good for the 84%. Just solely labeling a document, email, privilege is not going to get you that protection. Again, just to go back to, our particular our elements for an attorney-client privilege communication, it has to be and the 3 and 4 elements are most critical here. It must relate to what the attorney is being consulted about, and the communication must be made in the course of giving or seeking legal advice. Just solely saying that this is privilege or labeling it as attorney-client privilege is not going to get you there. And so that particular hypothetical is false. I want to move to our next one, which is corporate counsel's attendance at an internal meeting where legal advice was given about the meeting topic makes the meeting and the conversations therein privileged. I'll give everybody a minute to respond to this one. All right, what are our results? Okay.
We had 43% say true, 57% said false.
We got a little bit of a split. So this one is likely true, and I say likely true primarily because it is the providing of legal advice at the particular meeting, right? And so I would say that you could say in good faith at least that, look, the fact is that we discussed topic XYZ. And for topic XYZ, our legal counsel is there to opine and give us legal advice regarding topic XYZ. So all the documents and or communications that are exchanged for topic XYZ, while counsel is there and actually providing legal advice to us regarding topic XYZ, that's going to generally be privileged. Where it all becomes a little bit murky and why it says likely true is because that normally doesn't happen, right? That's not a practical implication. Generally, when you're in-house counsel, we're going to discuss topic XYZ, but then there are also other things that relate to topic XYZ that are not necessarily that we need legal for. There could be a compliance piece to it. There could be a business piece to it. And so because of that, there are other stakeholders there to opine on other things that those communications and where it becomes a lot more complicated is whether those communications themselves would be also protected by attorney-client privilege. And so I put an asterisk with that one just because it is likely true as stated. However, we all know in the practical world and practical implications that come with our meetings and the way meetings generally happen in the world, you're going to not just talk about one specific thing unless it's already in litigation. It's generally going to be, hey, we're talking about topic XYZ, and then we have such and such from compliance and such from the business stakeholder who also would like to talk about certain other things and how it implicates them as well. Moving on to the last one, all of corporate counsel's draft documents. Oh, I'm sorry, I'm a little ahead of the slide. But the last one is all of corporate counsel's draft documents are protected under the attorney work product doctrine. So I'll give you all time with that one. Let's see, it hadn't come up yet. And I'm not sure this slide came up for the question.
Yeah, I don't know why. I apologize. I also apologize for my typo. Let's see. Yeah, I don't know why. The question is, all of corporate counsel's draft documents are protected under the attorney work product doctrine.
Yep. All right, let's go ahead and close this one out as well and see where some of the folks fell on this one.
I don't know if you can see that. 34% said true, 66% said false.
Okay, so this one is false, and it really comes down to all, right? It's not all of your draft documents are going to be protected under the attorney work product doctrine. And I want to take this time just to kind of show the delineation between work product and attorney-client privilege. So work product doctrine applies to materials prepared in anticipation of litigation, right? It's either civil or criminal context, but North Carolina courts have narrowly construed the work product doctrine. And you have to remember that the work product does not cover documents or mental impressions of counsel created in the regular course of business. So all of your drafts, in the regular course of business, they are not going to be protected via attorney-client privilege or through work product doctrine. You're going to have to show and hit those elements, especially for, if it's work product doctrine that you're going to try to seek privilege for, you must make sure that it's in anticipation of litigation. And if it's the attorney-client privilege that you're seeking, you're going to make sure that any draft documents that you are providing, that you're providing them to provide legal counsel to your particular internal stakeholders. Those are going to be the main crux of what you're looking for in terms of those documents being protected by privilege. But for work product doctrine, the test requires materials be made in anticipation or for the purposes of litigation. And so therefore, all of your draft documents are not going to be protected. Again, these are just, quick hypotheticals. You put a little bit more meat to it. You could go either which way, but as it's stated, this one would be false. And so we see that although these concepts are concepts that we generally deal with on a day-to-day, they get pretty tricky, and they are that way because as in-house counsel, you wear two hats, right? You wear, and thank you for switching to the next slide. You wear two hats. A company is looking at you not only as a legal advisor, but also as someone that is able to have business acumen and determine, to help make business decisions in terms of moving, the company forward and to ultimately affect the bottom line. I just like this quote from the Window World of Baton Rouge. It says that although it is generally accepted that corporations may assert the attorney-client privilege, applying the privilege in the corporate context presents special problems. One such problem arises when an attorney serves a corporation in more than one capacity. Business advice, such as financial advice or discussion concerning business negotiations, is not privileged. Given the variety of corporate roles and responsibilities, it is given a challenging task to decide who speaks for a corporation and whether the person's communications with corporate counsel are subject to privilege. I mean, that really, kind of hit home that, there's not really, it's a difficult test, and it's not technically a bright line because as in-house counsel, you wear different hats on different days. And so you just want to make sure that the particular hat that you're putting on, whether it's providing legal advice and opining on legal things, you want to make sure that that's the correct hat to wear given that particular moment. Because ultimately, when you get a subpoena or there's a request for documents through the litigation process, you want to be able to say, yeah, I looked at that. I was opining on, whatever the topic or purpose was. And then that was, essentially why that document or communication should be protected. The North Carolina goes with the primary purpose test. So meaning that the primary purpose of the communication must be for, deciding legal advice. And so in terms of what the primary purpose is, it needs to be clear from your communications, how, or at least, what the purpose of your particular response and the stakeholders' response to you. So let's move to the next slide. So what strategies can we implement to make sure that primary purpose is clear? One is to make sure that in-house counsel uses a consistent signature block on all emails, started by them, replies, and forwards. The reason why I say that is you just want to make sure that there is a clear record of responses from in-house counsel. And if you're the GC, you want to make sure that your title is consistent throughout, as well as any other rank and file attorneys below you. That as long as that there's a record of everyone's response, that way at least it makes it easy in the event that it's a subpoena, or if it's through the discovery process for litigation, you can pull and say, all right, these are our communications that we have regarding this particular issue. And so it makes it a lot easier to say, all right, we pull those, and those, it's a lot easier to kind of go through. Second, ensure that the communication is sent to counsel and copies only people within the company with legitimate need to know the information. I think this is probably one of the most difficult. And I say that just because I speak from my own experience. When you have, whether it be a large or small company, you have to involve so many other people in terms of third-party vendors, consultants, and the like, just to depending on what you're doing. And so including those folks, whether those communications would actually be privileged or not, those are going to break your privilege. So you just have to be very laser focused all the time, as in, okay, if I include this person, will this ultimately break our privilege? Because it has to be a confidential communication. So just making sure that you are involving or including only the folks that really need to know that particular information or have that dealing on that particular project. Third, labeling the subject line and the top of the email with a privileged legend. Going back to our particular hypothetical, that solely is not going to get you there, but it is a good practice to do. So just make sure that you're labeling privileged and confidential attorney-client communication on the majority of the communications in which you are actually providing legal advice and opining on certain things. Also, ensure that the communication actually concerns legal analysis or advice. I think that goes without saying, that again, that's going to be a difficult proposition, because as in-house counsel, you provide advice on certain things that might be business related, and so just making sure that there is a legal analysis included within that, and in your particular communications back to your stakeholders will at least put you on good footing to say, hey, this does have legal analysis or legal implications to it. Do not discuss the contents of the communications with anyone else absent express approval. I think that one just kind of goes without saying. And do not start from the premise that the communication is privileged. So for any communication, especially when it's either via the discovery process or via responding to a subpoena or regulatory inquiry, start with the premise that, okay, this is not privileged, and then work your way back. I feel like that at least gives you the opportunity to kind of make sure that you're hitting all the particular elements that you need in terms of determining that communication is privileged. And one thing, at least for North Carolina courts, there have been a couple scenarios in which there have been found to be, or it's been held that there is attorney-client privilege or protected communications. One particular scenario is a communication by a non-attorney that reflects the in-house counsel's legal advice. So if there is a non-attorney such as paralegal, someone in compliance or things like that, that said, hey, I talked to our in-house counsel, Bob Wilson, and Bob Wilson says that on this particular issue that we should do X, Y, and Z. That's a privileged communication, right? Because Bob Wilson opined upon that, and he is just conveying what Bob Wilson said. And so therefore, that would be a communication that would be protected. And that has been found by, at least according to the Eastern District of North Carolina, to be a protected communication. A second scenario is the internal communication among non-attorneys that was made at the direction of counsel or to gather information that counsel needs to provide legal advice. So in terms of your internal investigations, directing some non-attorneys to gather information, not only would that likely be protected for in the event that you're anticipating litigation on it, you could possibly pick it up for work product doctrine, but it also would be considered a communication that would have attorney-client privilege attached to it as well. The North Carolina courts have held that there are certain communications that are not protected. So one scenario is a non-substantive transmittal, emails that simply forward along documents or communications without comment or containing only FYI. That makes me laugh just because I've seen that before, in which when I was in-house counsel, I would get a email and it would come in and it would say FYI ... And so that communication, we would likely have to turn that communication over. But I guess it was nice for my information. But again, that's not going to get us attorney-client privilege or get that as the protection. The subject line of emails are generally not going to be protected. As we go into, and I know we've seen this a lot, as we get more, I call it virtual, but and I know Candace will talk a little bit about ESI and things like that, but our privilege logs are becoming a lot more complex. And so the amount of emails and or Slack messages or Teams or whatever platform that you use, we're getting a lot of those. And so just the subject line themselves are not attorney-client privilege. You're going to have to disclose not only the subject line, but also the contents of it. And so just be aware that you can't just say, oh, this subject line will be attorney-client privilege. You have to operate as if it's not. Draft documents at the point that they are intended to be disclosed to a third party is not going to be held to be attorney-client privilege. So your draft documents that are disclosed to payment processors or third-party vendors or things like that are generally not going to be held to be attorney-client privilege, for the reason that they're not confidential. You are disclosing to a third party, and so even though they might contain information that is that you would deem privileged, or it at least has some of your as in-house counsel, it has some of your impressions, it's generally not going to be attorney-client privilege information. And lastly, communications made in the presence of a third party. Just like the scenario just mentioned, anytime you're disclosing something to a third party, it's not going to be considered attorney-client privilege. To the next slide. So in preventing waiver, absent a clawback provision in a protective order, North Carolina courts use the 5 factors to determine whether an inadvertent production of privileged documents or communication waives the attorney-client privilege. The first is the reasonableness of the precautions taken to prevent inadvertent disclosure. 2, the number of inadvertent disclosures. 3, the extent of the disclosures. 4, any delay in measures taken to rectify the disclosures. And 5, the overriding interest of justice. The reasonableness of the privilege holder in protecting and asserting the privilege is paramount to overcoming the consequences of inadvertent waiver. A lot of times, at least what I've seen in the past, is you generally have inadvertent waiver or inadvertent disclosure when there's multiple attorneys working on different aspects of projects that you're working on. So there might be a litigation component or when documents are turned over to an adverse party and the review of those documents did not cover that some were subject to attorney-client privilege and protection. So, if you're working on loan documents and things like that, and then a litigation comes that kind of encompasses those loans, and you might have a different law firm working on that, you need to make sure that you detail out for the law firm that's in litigation, all right, we had such and such attorneys that were working on this particular loan or this particular project, and such attorneys are this person, Candace Frill, Chris Blake, and you'll see their names in these communications. Please make sure that you pull those, as those would be attorney-client privilege. It's just making sure that you, detail out, who the attorneys are that you're using in terms of providing legal advice for a particular project. This also happened when devices are turned over for inspection, or where the device users didn't fully disclose how they were using the device. A lot of times you see it for the text message chains, when someone turns over their cell phones or things like that. There are certain communications that go to that may be attorney-client privilege, but when they're turned over, no one knew that they were using, that particular person was using their cell phone to actually communicate particular information. So it's just something that you want to be mindful for, and attempt to, for some of the strategies to avoid inadvertent waiver, attempt to have all internal communications subject to attorney-client privilege, maintain the privileged and confidential attorney communication, such as the slide that we have here. Make sure that it has that particular indication on the communication, just so again, if you have multiple law firms working on things, it's easier to pull and say, okay, this has this particular tab on it, I need to pull it, and make sure that at least check the information contained therein to make sure that it's attorney-client privilege. Obtain detailed information from document custodians about all of their work with lawyers during the relevant time period, not just the lawyers working on the specific case at hand. So you just want to make sure that you have a good working knowledge of everyone that's been working on those and who would be your particular custodians when you're pulling documents. If devices are turned over in discovery, to the extent possible, make sure that there's a review of privileged information is performed prior to turning over anything like an iPad, cell phone, laptop, anything of that nature. You just want to make sure that there's just no communications that you have missed in terms of when you actually turn something over, because you have a forensic person that's going to pull absolutely everything from that particular device, and so you just want to make sure that there's nothing there that will be implicated as attorney-client privilege. Those are all of my kind of opinions in terms of how to protect privilege. At this point, I'm going to turn it over to Candace Frill to discuss discovery considerations. Thank you for your time.
Thanks, Corey and Chris, and thanks to everyone for sticking around a bit longer. Of course, we saved the most exciting and probably your favorite discussion for last, discovery considerations. So let's go on to the next slide and just start out with just some practical points. And what do we do when litigation, or when it all hits the fan? The two big takeaways are, let's start early. And for you folks as in-house, know your technology. Those are really the two big keys, I think, to keeping costs down and to moving the litigation along as efficiently and effectively as possible, and to reduce errors. Understand your company's technology platforms. There's so many options out there now: email, chat, instant messaging. People have personal devices. We text. We use our cell phones, our personal cell phones, to text our clients and to text you all and to text other people within the company constantly. So just be very aware and very mindful of what those platforms are, because once discovery really starts, we're going to come looking for that. Your outside counsel is going to have to have a deep discussion with you and do a deep dive into all of those platforms. And so, the greater your understanding, the greater your outside counsel's understanding will be, and that's extraordinarily helpful in getting your case off to a really strong start. Please also, I would say, be really familiar with your company's document retention policies. Everyone is different, and that's fine. We see some with clients who retain everything for 3 years and then put everything in an archive. indefinitely, it seems, for some folks. I'm not sure I would recommend that necessarily, but we have plenty of clients who have much shorter document retention policies. They might have it for a 1-year period or a certain shorter period of time after an individual leaves the company. All that's fine. Just please be familiar with that, because once we get to a point where we're approaching discovery and going to start putting in a litigation hold, we want to make sure that we understand, that your outside counsel understands very clearly what they can expect once they start looking at documents, and that goes hand in hand with understanding the technology platform, because certain email systems will automatically archive, some will not. Some will archive for a particular period of time, some will not. Some are coded to delete permanently after a certain amount of time. So we want to make sure we understand and have a very clear view of what your policy is, no matter what it is, and how that applies to all the various platforms your company might utilize for communications, and keep those policies up to date. I think during any discovery or litigation, particularly during the discovery piece, your company IT personnel, they're going to be one of your best friends, because those folks are going to have all the keys that we need as outside counsel to walk you through all the discovery issues that are going to be popping up, and to helping us get the documents that we need, and working with sometimes an outside e-discovery vendor to pull documents from the company, or just working with us to understand some of the details or nuances about the documents that we're trying to get a hold of and review in response to discovery requests. So be sure you know who it is that we need to contact, and as early on as possible, get your outside counsel in communication directly with those individuals, so that when the need arises, we can have those conversations, and we can jump on these issues as quickly as possible. And some companies have a more robust in-house IT support staff and systems than others. And we're well versed at dealing with that in any capacity. And I can say, at least with our firm in particular, we have a very, very strong IT department. And we are always, I know I am constantly linking in my IT people, so that I have IT specialists talking to IT specialists, because I don't speak that language to the degree that these folks do. And so I think getting the right people to communicate with each other early on is extraordinarily helpful. They can ask the right questions. And so if you can be open to that, and open to those types of communications with counsel on the line as well, to guide the conversations, that's really helpful to us too. It really lets the experts talk the talk that they need to, and just ensure that every step we take is in line with where we need to be, and that we're being efficient and effective with that piece of the discovery. Be also very conversant in your company's policies regarding technology usage. There are some companies that have very strong, very detailed policies on how you can utilize email, personal phones. Some companies provide them for their employees, and some completely prohibit certain types of devices. So just be aware and be able to help your outside counsel understand when litigation's coming up, that here's what we have, here's what we support. We don't support mobile phones, or we do support them. We provide laptops to all of our personnel, or we provide tablets to them, whatever the case may be. We just want to make sure we're clear on what the devices are, what the policies are, what the expectations of the company, what those expectations are, so that we have a very fulsome sense of what exists out there and what universe of documents that we may be dealing with as the case progresses. And then also understanding and making sure your company has security protocols and proper protections in place to keep your documents and your sensitive information protected. That in and of itself, that one sentence is is a topic for multiple other CLEs and discussions by itself with cybersecurity these days. But just be sure that is something that is covered and that you are familiar with. Again, the more information that your outside counsel has, the better, the more efficient we can be, and the better we can respond to your questions and meet your needs when you are in litigation or approaching litigation. And so I think all of these things could help cut down not only on the amount of time that is spent dealing with the discovery, but it can cut down on disputes with opposing counsel later. And so just keep all of that in mind as you move forward. Next slide, please. So what happens when you are actually anticipating litigation? The litigation hold, that is the key first step, is to preserve. Can't emphasize that enough. Initiate a litigation hold to preserve potentially relevant and discoverable information at the earliest sign of a dispute or threatened litigation. The language from the Fourth Circuit, there's a key case called Silvestri versus GMC, and the language they use is the duty to preserve evidence arises not only during litigation, but also extends to that period before litigation when a party reasonably should have known that the evidence may be relevant to anticipated litigation. And so the way we typically handle that is we suggest you keep an eye, we recommend keep an eye out for triggering events that would inform you when this duty begins, because the failure to timely preserve evidence can lead not only to the loss of potentially helpful or exculpatory evidence, but in the worst case scenario, it could lead to a jury instruction for the spoliation of evidence. And no one wants that unless you're the one trying to get the instruction. And so we want to be very, very sure that we preserve everything out there, because again, there might be some, and usually there are some very helpful documents and pieces of information that we don't want to lose. And if you have a retention policy, for example, for 1 year, and there's some triggers coming up that makes you think that there's litigation bubbling, and perhaps a demand letter has been sent or something has been filed with the EEOC stating your employee is seeking a right to sue letter, and a year goes by, which it really reasonably can, before the EEOC sends out an actual right to sue letter, but you've deleted everything you had during that 1 year time, you might have lost some really valuable information there. So, most companies have your own sort of standard hold language that you're comfortable using, which is fine. But outside counsel is always available to provide guidance on that. We're happy to help draft that. We're happy to help review and tweak that to a particular case if that's needed. So don't hesitate to ask for that. But essentially, you'll be instructing everyone that receives it not to destroy information. Don't throw away your hard copies if you still have hard copies of anything. Don't get rid of emails. Any relevant information you have in any form needs to be held on to. So in terms of, when those triggers really come alive, or when should I actually send out that litigation hold notice, it's very fact specific, and there's no one case that tells us a very bright line rule. But I think arguably for an employment dispute, just as an example, if an EEOC claim is filed or someone in your organization is terminated and they turn around and file a claim of retaliation with the Department of Labor, that's perhaps a time to have a conversation with your outside counsel. Should I go ahead and send out a litigation hold in this case? Or if not, then certainly with it, at least at the issuance of a right to sue from one of those administrative departments, if it's that type of case. But generally speaking, it's going to be to your benefit to go ahead and initiate that hold. Federal Rule 3070 does provide that if electronically stored information was lost because a party failed to take reasonable steps to preserve the information, the court has some measures that they may order if they feel that any prejudice was caused to the other party due to that loss of the information. Or the court can find that, the other side acted with an intent to deprive the other party of the lost information. And at that point, the court can take the more extreme step of presuming the lost information was unfavorable to the party that lost it, and then instruct the jury that it may or must presume that the information was unfavorable, or they can dismiss an action or enter a default judgment. Those are pretty extreme cases, but it does happen. I had a case years ago that went to a jury trial, and we represented the plaintiff in that case, and it was an employment-related healthcare dispute, and the other side claimed that they had kept evidence that was very key to our case on a specific laptop and only on that laptop. And wouldn't you know it, during the course of the case, someone within the company took that laptop on a cruise and lost it on the cruise. They locked it in the little, I don't know how they got it in there, the little tiny lock box that they give you in your cabin room, and forgot it along with some medication. And when they realized that, they called the cruise line back, and the cruise line said, sorry, we don't find a laptop. So, the laptop went overboard, as we were able to argue, and we got a really nice jury instruction, and the jurors really punished those guys for it. So now that's an extreme, and that was a really fun one from that perspective. But just be very, very careful with how you preserve information and your documents. We just always want to be very careful there. I would say, and then just going back to our discussion about IT and the importance of having your IT involved, make sure that IT is contacted immediately, so that any part of the litigation hold that they can be involved in, usually they can lock down the emails and share drives, sometimes chat platforms, depending on what type of platform you have. IT can go in on the back end, so that you don't have to rely on a particular employee or individual to hold on to theirs. IT can usually go on the back end and lock a lot of that stuff down. So that's a sort of a second step to take as well. But your litigation hold notice is going to have to go out to anybody that you identify that could potentially have information that's relevant to the case. And so early discussions with counsel to help understand who those folks might be are very important, because it's if we send out the hold but we don't send it to the right people, it's not going to do us a whole lot of good. So but again, as soon as possible, have your in-house IT and your outside counsel connecting to make sure that the proper parameters that we can expect for discovery are in place, and just to make sure we're not losing anything, because we're going to assume that information is favorable to us. Let's go ahead. Oh, and just once the case is over, don't forget to remove the litigation hold. That's actually something that doesn't happen always, and that can come back to bite you in a later case, because you initiate a review, and it turns out you thought you had a couple years worth of documents to go through, but someone initiated a litigation hold and 6 years ago, and it was never removed. So actually documents have been piling up and emails have been piling up all this time, and we're going to be stuck reviewing those and potentially digging up a lot of stuff, or at least going through a lot of stuff that is going to extend the amount of time and money you have to expend on discovery, and nobody wants that. So don't forget to remove the hold at a later time. That is something that we do see with some regularity. Okay, let's move on to the next slide. Document collection and production. So once you've received document requests, obviously the first thing we want to do is sit down and very carefully review those with in-house counsel and the folks that you all help your outside counsel determine are the most knowledgeable about the issues that are involved in the case. And we're going to really rely upon you in-house to guide us to the right individuals. And the more we know, the better we will be able to review the production, and the better our production will ultimately be. Working with outside counsel to help develop initial search terms to tackle the universe of documents that we put that litigation on hold on is going to be really, really helpful. So some early conversations with the key players will go a long way in making that process more efficient. Most likely your outside counsel is going to, ultimately develop some written review protocols that the reviewers for the documents, whether it's an e-discovery vendor using contract attorneys or their in-house attorneys, depending on the size of the production, those protocols that are put in place are going to guide the review of those documents. And everybody looks at a document a little bit differently. So the more detail that we can have early on, the better those guidelines are going to be and the better that review will be. We will work with you as outside counsel to determine when it's necessary to utilize an e-discovery vendor to process and review documents gathered. If you've got a terabyte of information that's going to have to be reviewed, that's going to have to go to an e-discovery vendor, and there are a lot of them out there, and this is all they do. So these massive document productions now are really the norm in litigation. So we're very well versed at handling massive amounts of documents, and these vendors can do pretty amazing things with them. So those will be some early discussions that will happen regarding, what are we collecting and how are we going to review and produce that information. We will obviously have discussions about airing a protective order. We want to have a protective order with some tough confidentiality requirements in place before documents actually go outside the door. And as far as ESI protocols, those typically govern sometimes the scope of the review, but certainly the production requirements. What's the formatting of the production going to look like? How do we produce native files? What are the designations going to be on those documents? And so that is typically something that opposing counsels are able to come to agreement on, sometimes with a little guidance from the court, but typically we're able to get some ESI protocols in place early on, and that will help your e-discovery vendor and your outside counsel in reviewing the documents and knowing whether they, for example, need to image every document, which is not a cheap step to take, or will we be producing them in some other form or fashion. So we'll get those ESI protocols in place to kind of understand what it's going to be looking like. As far as the actual retrieval of information goes, again, that's the reason we want to have IT folks involved early on and have IT, in-house IT, as well as outside IT vendors discussing directly very early on how we're going to retrieve documents from your company, because metadata has to be preserved these days. I've not seen a production where that's not been a requirement in recent years. So we want to make sure that that's properly preserved, and therefore the method of retrieval is key to doing that. We also want to make sure that we're clear on who the custodians are that we will be retrieving from. As far as reaching an agreement for things like search terms and the specifics of the review with opposing counsel, there are different schools of thought on that, and I myself have different viewpoints and on different days of the week. It can be a very cumbersome process, but it can also force resolution of issues at the outset and keep the other side from being able to claim that a production was not fruitful, for example. Sometimes a court will require the parties to come to agreement on things as specific as the very search terms, the number of custodians, who the custodians are, the time frame of the document review. I've had that happen in the North Carolina business courts that Chris talked about early on in today's presentation. That's a pretty common thing that the business courts will require you to do. I've had that process itself take months to do. But typically, you will your outside counsel and or e-discovery vendor will work together to develop search terms, and they will do a lot of tests on the documents to see how many hits are we getting, how many hits are unique, and the testing is meant to ensure that we get a complete production of responsive documents, but also weed out the junk without having to manually review it. I would also note that from the outset, you typically do not want to just send everything that's captured under a hold to your outside counsel or e-discovery vendor, because that is surely going to capture far more data than is necessary and far more information, and that's going to be very expensive. I had a client do that recently, and we ended up with 4 million emails, not including families of the emails, not including all the attachments to the emails. We were able to use search terms and some other active learning tools through our e-discovery vendor in that case, and get that down to a universe of potentially responsive documents of about 50,000. So, however, bringing that 4 million over and whittling it down to 50,000 cost a lot of money, and it took a lot of time. So early on, we'll just exercise some patience there and work with your outside counsel and e-discovery vendor and your IT team to at least run some preliminary searches to the extent the company's software will allow it to just whittle those parameters down as much as we reasonably can, and before we bring it all over. The earlier we start, the better, because you cannot underestimate the, sorry, my automatic light, sorry. You cannot underestimate the time it will take to actually conduct one of these reviews, because something always comes up. So again, the earlier we can start, the better. And then let's go ahead and move on to the next slide. I'll just hit on this very quickly because we're coming up on the end of our time. Text messages, those come up regularly as questions now, and while discovery is generally limited to information within a party's possession, custody, or control, our courts have made it clear that this typically does include cell phone data, where that cell phone data is being utilized by even an employee if they're conducting company business. So the courts generally look at two factors. The first being whether the device is routinely used for the purpose of conducting the business of the company, and then whether the employer had a legal right to obtain communications from the devices. That second step, whether they had the legal right, will really sometimes boil down to provisions we see in employee handbooks, policies, or employment agreements. But I will say, for the most part, text messages are going to be discoverable, so brace yourself for that. And there are various ways that those can be collected and produced. Sometimes screenshots will be allowed, though they can kind of look a little bit awkward. But there are also text extractor apps and sophisticated software that an e-discovery vendor can utilize, and can actually go and sit down with an employee, plug it into this software, and download messages into an Excel-like document or format that can be then reviewed for privilege and relevance. So just bear in mind that that's likely something you're going to run into. And then next slide, ephemeral messaging apps. I'll just note briefly, these are becoming more and more popular. Be sure you're aware of what technology your company uses as far as instant messaging applications, if any. Some of them do actually maintain a record of the chat. Teams, for example, is one of those that does maintain a record, and that can be discoverable. But other ones do not. So I think generally speaking, most of the older apps are not captured or saved in any way, so they're not going to be retrievable. But just be aware that if you use Teams or Slack or something like that, you might be dealing with having to retrieve documents from one of those messaging apps as well. And then I'll just go to the next slide very quickly, just cost considerations. I think I'm sure you already know, electronic discovery has become one of the most costly aspects of litigation. But the earlier we start, the better off we can be to keep those costs down, and to make the experience as painless for you as possible. I think we've got about a minute left, and so I don't know if there are any questions anybody has to wrap up. If not, we thank y'all for your time.
All right, thanks, everybody.
All right. Thank you. We appreciate the time. Reach out with any questions.
Thank you. And everyone will receive a copy of today's presentation and a link to the video along with the presenter's contact information.